welcome to today's presentation. Hopefully you're here in the right place. We're going to be talking about H-1B visas and kind of all the way through to green cards. This is mainly going to be focused on employer-based options, employer-sponsored options, but I will mention a couple of self-sponsored options. Okay, so let's get started. Here's as I mentioned, the title of the presentation is H-1B visa to green card employer-sponsored options. Token disclaimer, because I am an attorney, we're going to be discussing some legal options in the presentation, but it's not specific legal advice for you. I am an attorney, not your attorney, so don't rely on this as me being your attorney. We always advise people to consult with an attorney, especially about travel or any specific options for you. So just please keep that in mind. And also note that things change. So while you may be watching this live today or recorded later, immigration policy and even the law perhaps can change. So just keep that in mind as well. Here's our contact info. I'll share a bit about who I am, but just here's ways to get in touch with our law firm, McEntee Law Group. There's our website, our email address, and pretty much every social media handle that you could imagine, both for myself, Fiona as the managing partner, and also for the firm as a whole. So, immigration policy does change frequently. Throughout the presentation, I'll be highlighting some of those changes that we have seen just throughout the Biden administration so far. So you'll be able to see why, it's important to keep up on some of these changes and how you can do that. And one of the ways that you can do that is by following us online. Connect with me on LinkedIn. I love hearing from people who've seen my presentations, and I do share a lot of stuff on LinkedIn. So that would probably be a good way to get in touch with me. Also, we have an email newsletter that you can sign up for, and we do a regular First Fridays with an immigration attorney and regular webinars. So lots of different ways to, keep up to date. So a little bit about me. I have been an immigration attorney for 16 years. I came to the US as an international student. So I truly understand how it feels to be in your shoes, because I was once in those very same shoes. And so I do a lot of work with international students, with startups, with O1 visas, and I've written a book as well that I'll share here, which is Immigration Options for Startups, Accelerate Your American Dream. It obviously, with the title, was written primarily with the startup founder in mind. However, there's a lot of info in there that I think is helpful for international students as well. So, we can send you the link. It's on Amazon, and it was written in a Q&A format, so hopefully you find it helpful to digest. Okay, so today's presentation, we're going to go over some immigration options and terms, going to talk about some policy changes, specifically, including the AI executive order, then the H-1B visa and some proposed changes there, some country-specific options, the O1 visa, which is another favorite of mine, and then some green card options. So that's a lot to cover in a pretty short period of time. So, let's get to it. And if you do have questions, please pop them in the Q&A. Okay, so some terms: non-immigrant versus immigrant. These are the two big buckets that we think about when we're thinking about immigration options to the US. So non-immigrant is really anything temporary, so any kind of visa type thing. Even if it can be extended, it's still considered a non-immigrant. It's a temporary option. Versus immigrant, when you think about that, you're thinking about permanent residency, which is a green card. So what are the common immigration options that people have or want to have here in the US? So for international students, your work authorization is coming from CPT, OPT, or STEM OPT. So that's while you're on F1, international student. There's some startup specific immigration options, International Entrepreneur Parole Program. There's some employer-based options that are sponsored by an employer, the H-1B, L-1A. There are some what I would refer to as country-specific options based on your nationality. You may have some additional options available to you, including the TN, some of the E-visas, H-1B1s, and then your green card options. So we'll go through most of these if we can. Okay, so international students, I think it's very important that you familiarize yourself with, the concept of work, and kind of knowing, or just familiarizing yourself with where you need to be careful and where the line might be crossed. So there's no real clear definition of work within immigration. So in order for us to really think about how work is defined, we look to different areas of law. And we see the definition that says performing services in exchange for compensation or value, which could be monetary or otherwise. And so a mistake that I see people make is thinking that because they're not getting paid, something is not considered work. And that's really not true. If your value is coming in other ways, maybe equity or, some other future kind of value, that could potentially be considered work and a violation of your status. And really the goal here is for me to encourage people to be proactive about this. It's very hard to try to repair some unauthorized work. And it's much better to be proactive ahead of time, look into this ahead of time. And I would encourage you to really, make sure that you're liaising with the International Students Office, because that's your main port of call for anything international student work, issues. So just keep that in mind as we delve into the other options. As you're a student, your work authorization is going to come from CPT or OPT, and please liaise with the International Students for some student office, your DSO for some specific guidance on that. Okay, so the Biden-Harris administration has actually been very pro immigrant, especially for people in STEM or tech or, different types of critical technologies. So this is a quote that we have seen from them that was in a statement, I think it was about 2 years ago, January 2022. So the Biden and Harris administration believes that one of America's greatest strengths, you can see there, is to attract global talent. And I use this a lot in our cases, because it's important to, kind of highlight this and reiterate this. And I agree wholeheartedly with this, that this really is our greatest strength. And we want to make sure that we have some great policy to back up those statements, and that's what the administration did. So in January 2022, along with that statement, they issued a series of policies that were very helpful, that have been helpful to perhaps people like you who are watching or could be in the future. So one of the things they did was they increased the STEM OPT fields, and then actually have since even added even more since then. And there were updates to the O1 policy manual, and I'll get into all these details later on in the presentation, but just know that these are the types of high-level overview changes that we saw. The policy manual for the National Interest Waiver Green Card was expanded, and then some changes to the J1. And then later on, we saw some additional updates to the policy manual for the EB1A Green Card. And then in October, just before Halloween, so on October 30th, we had this very extensive executive order on artificial intelligence. I get very excited about reading a 60+ page executive order. I know probably not everyone shares my enthusiasm, but it was exciting for me to read. Now, it covers a lot of different parts and kind of areas that intersect with AI, but there were several exciting immigration provisions, and the kind of announcement that came along with the executive order said that what the Biden administration wants to do is to use their existing authority within the law. So the president and the administration can add policy to the law. So they want to use the existing law and expand, the policy to high-skilled immigrants and non-immigrants with expertise in critical areas. So they want to be able to keep people here. And they want to modernize and streamline visa criteria and interviews and reviews. And so this was the aim of the executive order. Now, one thing to note is that the executive order lists several fields, which you'll see on the next slide, And it directed certain actions to be taken or to be reviewed within a certain period of time. So it doesn't necessarily create specific changes as of the date of the executive order, but it directs, the Department of Homeland Security, the Department of State to review certain specific immigration related areas to update them. However, this is something that I have been using, that we have been using here as a team to use to advocate for our clients already. So it's very important, even if the specific, policy updates are still TBD, it's still very important. So look, this is like a ton of text on this slide. These are the 9 main areas that immigration related in the executive order, related to visa appointments, renewing visa stamps in the US. So this is something that we've actually seen for H-1Bs. There's a pilot program that's just kicked off. But this executive order talks about expanding this to maybe J and F1 visa holders. Again, it's forthcoming, but it could be important for people who are here. The president wants to see some policy changes to the existing options for O1s and EB1As and EB2. So lots of different changes like that. And Schedule A, which would be fantastic to see. So Schedule A, I'm going to write a blog post on this, so you should sign up for our newsletter. It'll be shared there in probably a week or two. But Schedule A is basically a designated labour shortage occupation. The Department of State Department of Labour has designated certain occupations as being in, critical supply, where there's not enough US workers to fill certain positions. So it talks about updating this. Now, since I've been practicing over 16 years, and even before then, the list of Schedule A occupations has not been updated. Right now, it's nurses and physical therapists. So if this gets updated, this would be fantastic, because it could include a list of maybe people who work in AI or critical technologies, or, I know probably there's some people here just doing MBAs for management science or other types of critical fields like that. It could see perhaps those types of positions on the Schedule A list, which would really make the green card process go a lot faster for people, the employer sponsored green card process. So just know that these are potential changes that are coming down the line that could be very beneficial to people here. So, one of the main options that we're here to talk about today, with obviously the title of the presentation, is the H-1B visa. We're going to touch on, what the program looks like right now, and some proposed changes that we have seen that may be coming to the H-1B visa program. So H-1B visas are for people who are doing specialty occupations. And that means you're doing a job that requires a bachelor's degree in a specific field. A bachelor's degree or higher. So it could require a master's or higher in a specific field. But as written, it has to be a specific bachelor's degree. So not just any bachelor's degree, but like a specific bachelor's degree in a specific field. And the person must be qualified for the position. You must have that degree or the equivalent of an experience. Another requirement is that the employer must agree to pay you the prevailing wage or the actual wage when you get into H-1B status. And this wage is determined by either, if other US citizens are in the job, that's the actual wage, or the higher of these two, which is the prevailing wage, is determined by Department of Labour database, and the position category, the position location, and then the kind of level of the position as well. So prevailing wage or actual wage is a requirement for H-1Bs. If you've heard of the H-1B, you've presumably heard of the H-1B cap. And what does this mean? Well, the cap means that new visas are capped. There's an annual cap, so a limit of 65,000 new H-1Bs plus 20,000 for those with US master's degrees or higher. So there's a limit to how many new H-1B visas can be issued in any year. And because the visa has a lot of benefits and just the sheer number of people who want it, there's just very high demand and there's a limited supply. So, you know, obviously where the demand is so high and the supply is limited, you know, demand has far exceeded the supply of H-1B visas. So what's been happening for pretty much almost every single year since I've been practicing, minus like 1 or 2 years, there was a lottery to see which cases could actually be adjudicated or filed because the demand was so high. So I just kind of pulled up some numbers here. So in March 2022, 500,000 applications were filed for registrations. March 2023, nearly 800,000 registrations. And we really saw these great numbers because the system was actually changed a few years ago. So previously, let me see, is the next thing a chart? If there's a chart, I'll go back to this. So this is how the system works now, where you do the registration and then there's a lottery and then you file the case. Previously, everything was filed on April 1st and then they did the lottery. So it was a lot harder to enter the lottery because you needed to file a full petition. But with this new registration process, people were able to do the registration, you know, pretty, you know, quickly. And what happened was that we saw a lot of people submit multiple registrations for all these different employers. And the USCIS says there was some alleged fraud there because with the registration, the employer, future employer, was supposed to submit an attestation. So it was to attest or agree to the fact that there was a bona fide job. There was a legitimate job. It was a legitimate registration. And the USCIS said there were some people submitting, 10 plus registrations from different employers, and that there was companies that had popped up that were agreeing to submit all these registrations for people. So basically we saw the numbers of registrations increase so much because people were trying to get as many registrations in as possible because every registration gave them a different chance of getting selected. So that was what has been happening in recent years, and it's been increasing to like 800,000 last year. So they ended up doing multiple lotteries because the cases that were pulled to be eligible for filing were not all filed. So the system has definitely been broken. And this is the system here. So I touched on this just briefly, these dates are based on previous years. We're not actually sure how this is going to look this year. So the timeline was during the first few weeks in March, you would submit your H-1B registration. The employer would submit a registration on your behalf, attesting to the fact that, there was a job available for you. Then towards the end of March, normally the government would take all those registrations and conduct a random lottery to see what cases could then be adjudicated. And there's 2 different lotteries done. One is the bachelor's degree lottery, and then the second is the master's degree. And then you would get a notice that said you got selected in the lottery, and then the employer would have 90 days to file the H-1B case on your behalf. So this is how the lottery was working. March deadline. Then, let's say lottery finishing April 1st and then 90 days to file the case. So that's kind of how things have been for the past few years. And I'll touch later on the proposed changes, but up until now, that's how the system has been working. Now, this is for companies that are cap subject. There's a subset of employers that are exempt from the cap. These are universities and related or affiliated nonprofits, or nonprofit research institutions or government research organizations, and nonprofits that are doing research. So these employers, if you're going to work for one of these, they're not subject to the cap at all. So they can file, so that means there's H-1Bs available for them year round, and they can file a H-1B for you at any time of the year without going through the lottery. Now, a massive benefit of this as well is that there's a concept called concurrent H-1B. And this means that if you were working for, let's say, a cap exempt organization, so you can also have a second H-1B for a company that would normally have to go through the cap. So you can concurrently have 2 H-1Bs, one being cap exempt let's say a non-profit that does research, and then you could have a second one. Normally one of these would be part-time. You couldn't probably have 2 full-time jobs like for 40 hours each week, like 80 hours a week, but one would be part-time normally. And there are certain programs that have been established to kind of facilitate this. One is a global entrepreneur in residence program that's been done through certain universities, and then there's another one, there's a program called Open Avenues that also does cap exempt programs like this. So it's having these 2 H-1Bs at the same time because of the fact that one of them is cap exempt. So just wanted to throw that out there. It can get a bit complex delving into the intricacies of cap exempt and how do you determine which is cap exempt and structuring the petitions and filing the second one, but just know that there is a concept called cap exempt H-1Bs. So I mentioned that there are some proposed changes. Part of, for the government to change regulations, they have to go through a certain procedure. And that involves issuing the proposed regulations, allowing the public to comment on those proposed changes, reviewing those comments, and then issuing final regulations that will go into effect in a certain date in the future. So right now, the comments period is closed for these proposed changes. So proposed changes came out in October and we all reviewed them. We all submitted, I worked with numerous groups to submit some comments, and the government is reviewing the comments now. So the proposed changes were the one that I really want to highlight. There's like a whole bunch. You can see that there's like proposed regulations were very detailed, and we just don't have time to get into all of them. We're nearly halfway through the presentation, but the really important thing is that they were going to change the lottery to a unique beneficiary system. So what that would mean was even if you had 5 employers submit different registrations on your behalf, you only get 1 chance of getting selected. It's a unique beneficiary system. So every person just has 1 chance of getting selected, regardless of how many potential employers submit registrations for them. So it essentially levels the playing field in that sense, and this was a very welcome change. There's some other things it did where it extended what's a cap gap, which is like OPT that goes beyond the end date of the OPT. Revised the definition of specialty occupation. There was a lot of comments, I think, related to that. Then some deference, which is like kind of this is more for people who've already had H-1Bs. They're also expanding potentially the definition of who could be cap exempt, which is great. There was a purpose behind that. They want to encourage more employers to file under the cap exempt, assuming they meet the new definition. So anyway, and some changes for immigrant founders which was very exciting for someone who does a lot of work with startups. So to make it easier if you own the company, to make it easier for that company to sponsor you for a H-1B visa. So that was great. These are the proposed changes. We don't know what type of timeline we're dealing with. We're not sure. I did hear some talk of perhaps the changes being phased. So for example, they may determine that the most important proposed change is this unique beneficiary. So maybe we may see that before March. I don't know. It's obviously January now. So that might be, they may determine that that's the most important change, and let's put all the resources into changing that now. And then the other changes can be phased over the course of, who knows how long. Now, also, they may also revise some of the proposed changes based on the comments as well. So, these are proposed, but I just thought it would be helpful to share so you can see what potentially could be coming down the line. So that is everything for the H-1B. I will take any questions when we get to the end, but for now, we're going to move on to country-specific options. Again, this is depending on your nationality. So here are the options that you may be able to avail of. If you are from Mexico or Canada, or if you have nationality from one of those countries, you potentially could look at the TN option, which is based on a treaty between Mexico, Canada, and the US, and it is for people doing jobs in a specific list of there's a more finite list of occupations, and if your job can fall within there and you're qualified for it, then potentially you can get a TN, which would be a great option. There's no limit and no cap and no lottery, so it's available year round. So just putting that as a potential option if there are people from either of those countries. There's also potentially an E1 or an E2 visa if your country has a treaty with the US. So there's some big countries that do not, like India or China, but there are lots of countries who do have treaties with the US. This is really for people who, the E1 is a treaty trader. So if someone's working for a company that has the nationality of, so is majority owned by people from a country that has a treaty with the US. I'll just use Ireland, for example. If you're working for a company that's majority Irish owned, and that company has, majority of international trade with the US. So for example, your company, the company's manufacturing dairy, Irish dairy, and it's shipping, to the US, and the majority of the international trade outside of Ireland is between the US and Ireland, and you potentially could get an E1 based on that, like, trade, majority trade relationship. The E2 is for an investor visa. So if a company has invested in a new or existing company in the US, and you share the nationality of the company, that might be an option. H-1B one is like the H-1B, but for Chile and Singapore, for people from those countries. And there is also a cap for those, but it's, I don't think, ever really been met. So essentially it ends up being available year round. And then the E3 visa is like a H-1B, but it's for Australians. So throwing those options there. The O1 visa is an option that I love to do, and we do a lot of these in our firm. So it's for people who have extraordinary ability. Now, sometimes people get really put off by the term extraordinary ability, and like they call it the Einstein visa. I've heard this term, just people get intimidated by the idea of like an extraordinary ability visa. But I'm here to say that it does not mean that you have to have 20 years of experience. We have successfully done O1s for people from OPT, so it is potentially possible to go straight from student visa to O1, just depending on the specifics. An extraordinary ability can be in various fields. So it's not limited to any particular industry. Science, business, education. Then that's O1A, and then the O1B is the motion picture, TV, or the arts. So we want to make sure that we're defining your field of expertise. And, while saying that you shouldn't be intimidated by it, just know that not everybody's going to qualify for the O1. You do have to show that you're at the top of your field. And it does take time to prepare these cases. Normally it's like hundreds of pages of documentation that goes into it. But the great thing is they're available year round, so there's no cap for people. So what would it mean to be extraordinary, and how can you qualify for the O1? So this is like the representation in my brain of what I think about when I think of the O1. And I like to tell people that you need to think about filling 3 different buckets. The first bucket is evidence of extraordinary ability. The second bucket is there needs to be a petitioner that's going to file the case for you. And then the third bucket is that you need to show you're going to continue to work in your area of extraordinary ability. So, there's no point in having extraordinary ability in one field and then wanting to do something completely different. There needs to be some kind of true line, some synergy of relating to your past work and your previous work, or in your future work. So how do you prove that you have extraordinary ability? Well, this is the list for the O1A. So there is a potential 8 boxes that we can check, and we want to ideally check 3 of them. I've done a whole series of videos on these on like various social media platforms that we can send, where I get into some of these a bit more in depth, and also in my book as well. But prizes or awards, working in a critical or essential capacity for distinguished organizations, that is one that I use a lot. Press, if there's press about you, now you need to be named in the press, but if you're not named and a company was named, but we could somehow tie it to you, we might use it in a different way, but not necessarily for press. Original contributions of major significance, that's one that's a great one to use as well. Scholarly articles, so if you've written some articles that have been published in some professional journals or other media, that would be a great one to use as well. High remuneration, so that, if we can show that you're getting significantly more than your peers, and there's ways that we can show that with kind of wage surveys and databases. Serving as a judge on as the work of others, that's one that can be used for people. Depending on your industry, there can be some opportunity to do some judging, and then being a member of associations that require outstanding achievement. So this is the list of 8. We want to ideally show 3. And there were some great, I mentioned at the start that the Biden administration has issued some policy changes, and this is one where we saw some really great policy. So the law shows the 8 criteria. The policy now expands on the law and gives examples, and that was not there before. So the O&A policy manual has now the list of all those 8, and it has some additional context. So I highlighted one here for people to see. So this is the awards box, okay? So there's some specific examples that says, awards from well-known national institutions, certain doctoral dissertation awards and PhD scholarships. Before, it wasn't clear that would qualify. And they've also included awards recognizing presentations at nationally or internationally recognized conferences. Also, that was not clear before. And so some of these things, I think, have come from arguments that attorneys have been making for years, where we were arguing that this is what the awards should mean. And now the government has acknowledged that, and by putting it in black and white in writing in the policy manual has been super helpful for us to be able to rely on that. If you are getting a PhD, there's some really helpful stuff for PhD, but not exclusively. There's also some other great things in there to really enable us to craft a strong case for our clients. Okay, so that is the O. I'm just going to do a quick check on time. Okay, we're still good for time. So now we're going to get into some green card options. And there are potentially some other non-immigrant visa options as well. Obviously, for purposes of today's presentation, I can't cover every single letter of the alphabet in terms of visas, but I just wanted to cover the ones that I felt are the most relevant or most common. Okay, so some green card options. And I hope that you're finding the presentation helpful. I really enjoy being able to talk to international students because, as I mentioned, I was in your shoes before and I really do know how it feels. And I want to empower you to take ownership over your immigration journey. And one way you can do that is by educating yourself on potential options that are available. And I think, with immigration, as is with life, preparation and dedication and, passion and drive, is all those things are really going to help you, and hopefully be positive factors in your immigration journey. And that's really what my goal is, to give you this info so that you can be proactive about it as well. Okay, so some green card options. This is a green card. The EB-1A is really like the green card version of the O-1A, which is the extraordinary ability visa that I just discussed. Now the standard is higher for the green card than for the visa, and that would make sense, right? It's a permanent, it's permanent residency, so the standard should be higher if you're going to be able to be here permanently. And you do not need an employer for this, but you do need to show that you're going to continue to work in your field. Now, I think this is the extent of the info that I have here on the EB-1A as far as slides go. But I have done a full hour presentation on this and on the National Interest Waiver Green Card that I can send you. So a full hour just discussing this option and the next option that I'm going to discuss. The policy manual was also updated for this, and including some additional, modern info about how people might be able to qualify. It also discusses, if people have been approved for an O1, while it doesn't guarantee that you're going to get an EB1A, it's very good evidence to support your EB1A case. So, you're able to self-sponsor for this EB1A. I know the focus of the presentation today as well is kind of employer-sponsored options. But even if you're working for an employer, you could also simultaneously be exploring green cards. So even if you were getting a H-1B through an employer, there's nothing that in theory would prevent you from looking at a permanent residency, perhaps on your own or in conjunction with something that your employer is doing. So just to keep that in mind as well. Okay, another green card is the EB2 National Interest Waiver Green Card. Please pay attention to this part of the presentation. I hope you've been paying close attention to all of this, but the National Interest Waiver is like the hottest topic in immigration. You can also self-petition for this. And now you are able to premium process the I-140, which is the first part of the National Interest Waiver Green Card. Previously, you were not able to premium process that part, and it was taking so long for these cases to get adjudicated. So what are the requirements for the National Interest Waiver? Well, you must have an advanced degree. So it's a PhD or a master's or higher, or a bachelor's degree and 5 years of experience. Or demonstrated exceptional ability in your field, which is like a whole kind of mini O1 almost. So, but if you have an advanced degree, then you're checking box number 1, right? You don't need to also prove that you have exceptional ability. You're qualifying for the first part based on your advanced degree. And then the second part is proving that you meet all the elements of the national interest. So this is that your proposed work must have substantial merit and national importance. You must show that you're well positioned to advance that work, and that in general, we should allow you to sponsor yourself for a green card. So substantial merit and national importance. So essentially we're looking at what's the problem that you're solving or the work that you're doing, and is it in the interest of the US? I think if anybody's working in AI or these critical technology fields, we have a list of critical technology fields. Well, we have a 60+ page executive order from the administration talking about the importance of AI. So, I couldn't think of better evidence to show how AI and these critical technologies are in the national interest and are nationally, they're important on a national level. And we want to show that the work that you're doing, it's not very regional and localized. There should be an impact that goes kind of beyond just your locale, which, if you're working in software or, things that are touching like a wide variety of people, then that would be something to think about there about how we could show that. And then that you are well positioned. So showing that you have experience or that you have some critical, skills or education, very relevant education. And that again, that on balance, you should be allowed to sponsor yourself. So I think that the bulk of the scrutiny is more on the substantial merit and national importance. And if you have that education in that relevant field, well then, that is something that I think is we can make some strong arguments there to show that you're well positioned to advance that work. So we've seen some great policy updates here, and we may even see more based on the executive order on AI as well. But the policy updates that came in January 2022 was that the USCIS is considering an advanced degree in a related STEM field, and particularly a PhD, but not exclusively. So if you have a degree in at least a master's or a master's or higher in like in a field that's like STEM orientated, is the government should consider that an especially positive factor in adjudicating these cases. And the officers are directed to look at the importance of the critical and emerging technology fields. So this is like really, really great policy that we can use to allow people to self-sponsor for green cards. Now, this is an EB2 green card, so the other one was an EB1. And so what that means, EB is employment based and it's a different category. So it kind of can potentially impact how long it might take you to get your green card. And if there's a backlog. So that's a webinar for a whole other day, because it would just take too long to get into the intricacies of that. So there are two ways that you can self-sponsor for green cards, the EB1A and the EB2 National Interest Waiver green card. There's also a kind of a traditional employer-sponsored green card, which is known as the PERM process. So this is a 3-part process. And the employer is really recruiting to show that there's no qualified US workers available. These cases fall under 2 categories, normally EB2, employment-based 2, also an EB2 like the National Interest Waiver cases, or EB3. And so whether it's EB2 or 3 depends on the requirements for the position. The EB2 is the master's or bachelor's in 5 years of experience, and then anything less than that puts you in the EB3. So the timeline for actually getting the green card depends on the category, the EB category, your country of birth, and a few other things. So really you need to make sure that you have work authorization or status all the way up until the final stage of the green card process. So this is what the stages look like in a traditional employer-sponsored green card. So the first stage is the PERM, which is the recruitment process. The second stage is the I-140 petition, which is the immigrant petition. And then the third stage is the adjustment of status, which is the I-485. And with that comes travel and work. So to kind of put some additional context onto this, the first stage is that labor certification, that recruitment, showing there's no qualified US worker available. If you recall earlier on at the start of the presentation, I mentioned the Schedule A, where the Department of Labour has said there's like a kind of a national shortage of nurses and physical therapists. So for those cases, they don't have to go through the recruitment process because the government has said it would be futile because we know that there's no qualified workers available. And so the hope would be that if those Schedule A fields get expanded, then this process becomes a lot quicker for people because their employers don't have to go and recruit and show there's no qualified workers available. If you were doing those self-sponsored green cards that I mentioned, which is the National Interest Waiver or the EB1A, you're skipping step 1 here. It is a 2-step process: the I-140, the immigrant petition, and the adjustment of status application. Depending on what category, what your country of birth is, the time of the year the case is filed, you may potentially be able to file the I-140 and the 485. So in this chart, step 2 and 3, which really is like step 1 and 2 in a case that doesn't need a PERM. So you potentially can file both parts of those together at the same time and include a work and travel permit. But that is that's a case by case analysis depending on your category and your country of birth and what the visa bulletin, which is the green card availability, looks like. But that's like an overview of how the process looks. As you can see, I think it's pretty clear that there's a lot of changes happening. Now Congress, which is obviously the entity or the whoever's in charge of updating the immigration laws, the laws have stayed the same, but the policy keeps changing. So please, hopefully you'll follow us online, connect with me on LinkedIn, join our newsletter, and watch some more of our webinars to see. I am especially excited to see what's going to happen with the H-1B visa process, especially this unique beneficiary lottery. And we don't know when we'll get more info. Here's a way to contact us: our website, our email address, and some various social media handles. I'm going to stop sharing. And I am going to see, I think somebody asked a question here. So somebody is saying that the hard part is finding an employer, that nobody wants to, I guess, sponsor people now. So that, my experience has been that, obviously our firm is an immigration law firm. So we work with employers and employees all day long. who are willing. So I think it really depends on, there certainly are employers out there that are sponsoring people for visas and for green cards. I think that it just depends on the employer, it depends on the individual. If you are a student and you have the ability to get some CPT, which will enable you to, get a job while you're enrolled in school, I would encourage you to look into that, because that's a great way to get your foot in the door to then, show why or how, that you're a great asset to the company. So I would encourage you to look into work authorization options that you have as you're a student. Also with OPT, you get a year and then potentially the additional 2 years. So that's maybe up to 3 years where you can work for an employer and prove your worth and show how you're such a valuable team player, which I know you are. And think about how far you've come to get to the US. It's not easy to get your student visa, to enroll in school, to it's none of that is easy. And you're in, an amazing university here. So don't forget how far you've come and how determined you already are. And so use that to, propel you to motivate you further. And there definitely are companies that are willing to sponsor people. I think it just is a question of finding them and seeing which companies they are. I'll tell you just a very brief story that when I was here in law school, I was studying immigration law as one of my classes, and at the end I went up to a guest professor and I asked whether he thought I could get somebody to sponsor me for a H-1B after my OPT ended, or whether he thought I could stay. And he said that he didn't think anybody, he basically said he didn't think so. And that, regardless of anything, that I'd probably have to go back home to Ireland, which was very upsetting. And, I now know that he didn't even work in employment immigration. And from there, I kind of took that as I was even more determined to find an employer. And I did find an employer, and I was able to stay here. Now, years later, I'm a naturalized US citizen with a firm of 16 people, and we help people like you all day long. So I want to encourage people to don't listen to those no's that you get, seek out the yeses, and they are out there. And look at the resources that you have available to you, whether it's in Northwestern, Kellogg, the International Students Office, there's career coaches, alumni groups. There's just so many resources. And so I just want to encourage you to reach out to them and to, hopefully be able to make some of those connections, because I have seen people do it and I know that you can do it too. Okay, so I've answered that question. This is going to be, if you have a question, pop it in. Otherwise, we're going to be wrapping up, but I have one more question. So someone's asking, what are the requirements to keep a green card once you have it? Can you go back and forth from your country of origin? So yeah, green cards allow you to travel back and forth. There are some requirements in terms of having the US be your primary place of residence. There's some tax filing requirements. If you wanted to leave the US for an extended period of time, you would need to talk to an attorney. You can potentially file for something that's known as a re-entry permit, and that preserves your green card if you're going to be gone for a while. There are some requirements after you get your green card. There's some do's and don'ts. You shouldn't register to vote. You should never, claim to be a US citizen. You can potentially lose a green card for certain things that, make you deportable, like some criminal offenses and so on and so forth. But, generally you can travel in and out. You can work, for pretty much any employer, as long as you're not required to be a US citizen. There may be some federal jobs that require that. But it gives you a lot of flexibility. I've gone through the process myself, and then potentially apply for citizenship down the line as well. After having a green card for a certain period of time, you can potentially be eligible for citizenship. Okay, so someone said they joined late. Will I share the presentation? Did I cover details on the TN and on the path to green card? Yeah, we're going to have a recording of the webinar, so we'll find a way to get that to you. Liz, our marketing manager, is incredible, and she'll send you some info post presentation, assuming you registered for it, so you can find a way to get that. I did talk about the TN, but very briefly, I just mentioned it as an option for people. You can potentially go from TN to green card. The TN is a temporary intent visa though, so there are some things that you need to be especially aware of, and certain maybe travel restrictions at certain points in the process. But I would be happy to talk to you separately regarding that. We have definitely done green cards for people from TN. But there's just some additional considerations that you need to think about, because it's not a fully dual intent visa. You may also want to look into entering the H-1B visa lottery. Even if you can get a TN, the benefits of the H-1B, one of the main benefits is that it's a dual intent visa, so you can apply for a green card at any point in the process and travel, and so there are some added benefits to the H-1B visa. So for that reason, you might want to see if would it make sense to enter the H-1B lottery. It might. So hopefully that was helpful. But yeah, thanks for jumping on. Even if you were late, we can figure out a way to get the webinar to you. I hope everybody found this helpful on a cold January day here in Chicago. I just appreciate being able to share some of my info that I've learned over so long with you, and I'm excited about some of these proposed changes and some of the changes that have already happened. So stay tuned on that, and hopefully I've given you some food for thought here, and I am looking forward to just continuing to serve as a resource for you. So please get in touch with us. And you're very welcome. Thank you for having me, Sandrina. It's great to be able to share, this info with the students. And I do, from a personal point of view, it means a lot to me having walked that path myself. So hope everybody stays warm, dry and safe, and hopefully you'll look forward to the next webinar that we're doing, and we will talk to everybody soon. Okay, take care. Bye-bye.